Welcome to the next episode of the Austin Bar Association's Council of Firsts. I'm your host, Amanda Arriaga, First Latina Bar President. Today we talk to the justices of the Third Court of Appeals. For the first time in history, this court is led by all female justices. Darlene Byrne is the Chief Justice of the Third Court. Prior to this, she served for 20 years as the presiding judge of the 126th Judicial District, which is responsible for all child protection services cases in Travis County. She is chair of the board of Tex Protects, is on the executive committee for the Council of Chief Judges for State Courts of Appeals, and is a past president for the National Council for Juvenile and Family Court Judges. Gisela Triana was the first Latina elected as the 200th District Court Judge and first Latina to be elected to the Third Court of Appeals. She's been recognized as Judge of the Year by the Hispanic Issues section of the State Bar of Texas, received the Habla con Orgullo Award from the Hispanic Advocates Business Leaders of Austin, and the President's Award at the Hispanic Heritage Luncheon presented by the Hispanic Bar Association of Austin. Shari Kelly is the immediate past president of the Austin Bar Association and chair of the Austin Bar Foundation. She's the recipient of the Texas Young Lawyers Mentor of the Year Award and Travis County Women Lawyers Association Trailblazer Award. Justice Kelly is a U.S. Army veteran and former paratrooper. Rosa Theophanes began her career in public service as an assistant county attorney and assistant district attorney for Travis County, including 10 years in the appellate division prior to serving on the Third Court. She also worked for a nonprofit in Washington, D.C., providing civil legal services to survivors of domestic violence. Karen Crump served as the presiding judge of the 250th District Court for 10 years prior to serving on the Third Court. She currently serves on the board of editors for The Advocate, the quarterly publication for the State Bar of Texas Litigation Section, and previously served as president of the Texas Association of District Judges, chair of the Texas Supreme Court's Task Force to Expand Legal Service Delivery, and president of the Texas Young Lawyers Association. Maggie Ellis served as a prosecutor for the Travis County District Attorney's Office and was appointed as an administrative law judge for the State Office of Administrative Hearings. She is chair of the State Bar Juvenile Law Section Board and has received the Hayes County Bar Association's Pro Bono Hero Award. Each of these justices received very abbreviated biographies because their accomplishments would take up all of our time, and I prefer you hear directly from them. Please welcome the historic Third Court of Appeals to the Council of Firsts. Welcome, the justices of the Third Court of Appeals. You are the historic justices for this court, the first time being all female. Thank you so much for being here. Thank you for wanting to do this and being willing to talk about why this is important. Justice Byrne, why is it important that the Third Court of Appeals for the first time is an all-female court?
Well, I guess my question is, why hasn't it been all-female before now? But for a history lesson, our court began in 1892, and for 94 years thereafter, this court was presided over by all men until the mid-'80s, when the wisdom to appoint Justice Marilyn Abusi as the first female to our court. And about a decade later, she became our first female chief. I am now our second female chief. So from the mid-'80s until this past January 2025, this court has been a mix of genders, a mix of cultures, which is a wonderful thing. But on January 1, 2025, we became 6 female justices to preside over the Third Court of Appeals for the first time. And as our RBG says, women should always be in the place where decisions are made. And so we are here.
Well, thank you for that. And also, to paraphrase RBG, there will be enough females on the court when there are 6. What would you say to the naysayers that have argued that it's easier to get elected in Travis County for a woman?
Well, they haven't been on the campaign trail with me. I think being a candidate and being a mom and a partner and a full-time lawyer or a full-time state trial court judge or a full-time justice while you're campaigning, one would see is about 3 to 4 jobs simultaneously. There is nothing easy about this. Each one of these women that are sitting before you today earned this position professionally and with blood, sweat, and tears, and with their money.
Well said. Justice Triano, you are one of the 2 longest-serving justices on this court. What have you seen change in your time on this court?
Um, it's funny because you would think, when both Justice Kelly and I came in 2018, well, we got elected 2018, came in 2019, the court was divided politically, and was so for a while. And you would think that the most obvious thing would be like, oh, having different political stripes on the bench would be a big change. But I have found that that is not at all. Everybody that I have served with on this bench has done the best that they could and called balls and strikes without, any reference to political stripes. I think I'd say there's 2 things. One, just practical. In 2020, we had COVID. And then not long after that, we had a ransomware attack. And so we were without computers for a while. And, if you're old like me, everything I used to do was in paper. I read briefs in paper, I printed everything. And so one of the biggest changes is that we've gone all now to basically computers. So we do, it used to be that for circulations of opinions, you'd have an inbox, and then whenever they'd come and you'd have your name on it. And I would, with purple, because I don't like red, ink would change it. So that's a big change in that we're all now completely digital. And that's for the good. And it's made people like me kind of kicking and screaming, having to come into the 21st century. I'd say the other big change, which has nothing to do with our court or the people on our court, is what I consider the politicization of the court by others, specifically the legislature. So we came here and we won in 2018. The first time that the legislature met, they tried to redistrict us immediately that year, all of the courts of appeals. That didn't go very far. The second time they came, it was the first time, right? It was right after we got here, right? In 2020. And so then the next time after that hadn't worked, they basically decided they're just going to take certain functions, our administrative function that has traditionally, ever since ever, administrative cases that have been in the third court because they come to Travis County. And so, as you know, the administrative cases, if you're appealing from an administrative agency, it'll go to a Travis County District Court. That's where venue is. And since the third court was the court that the cases from Travis County went, we heard them. And it's been like that. And nobody really had a problem until the politics started changing. And so we have now a new court that handles those for different arguments, for the reasons that be. But I can tell you, and it's not just in the state, but nationwide, that it feels like being a judge, and I've been one for almost 30 years, is like having, a bullseye on you. Whether it's people don't like independency all of a sudden of the third branch of government, of the co-equal third branch of government, and they expect us to be political, which is exactly what we should not be. I think, Chief Justice Roberts said it. We don't have Obama judges. We don't have, or at least we shouldn't have Obama judges, and we shouldn't have Trump judges. We should just have fair judges. And so it's made our job worse.
And if you think about after we were elected, that was such a big change for intermediate appellate courts. There were CLEs that were tracking the opinions of the appellate courts and said, okay, well, all these Democrats got elected. Are plaintiffs winning more often? Are defendants in criminal cases winning more often? And that was not the case. And even thinking back to our court when we were divided politically, how many dissents did we have in 2019 and 2020? Not a lot.
If all you did was read opinions, I don't think that between the time that it was 6 Republicans to 4 Democrats and 2 Republicans, you'd go, oh, there's a really big contrast in what the third court is doing. That never happened.
And then I don't think that the public understands we have only 30, 34 employees. And of those 34 employees, each of us have 2.5 staff attorneys. Many of our staff attorneys have been with this court a decade, 15 years, 20 years. We've even got one employee that's going on 25. These employees that stand ready to serve the citizens of this state and have for years have worked for Republican leadership, mixed leadership, Democratic leadership, and these lawyers and paralegals, as we do, we just want to get it right. And our job is to follow the law and interpret the law if it hasn't been clarified, if there is something to clarify. And that is what we try to do every day.
Does it ever feel defeating that this court happens to be aligned politically, but you might not be aligned with the Supreme Court? So your staff, you do all this work, you write these great opinions, and then get overruled. As an outsider, sometimes what we'll see is, well, of course the district court did X, and of course the appellate court upheld it, and of course the Supreme Court reversed it. What does that feel like? As the intermediary court, what does that feel like to spend all of that time and effort to do that?
I'll tell you, even before we take the politics out of it, I mean, we are not a monolith. We don't even sometimes agree with ourselves. I mean, there's dissents that are written, even though we're all Democrats and we're all women. And so I would say, as a judge, it never feels good to be reversed by the Supreme Court or the Court of Criminal Appeals, because everybody's trying to get it right. But having said that, that's across the board, not just politically, not just because we think that somehow they're looking at us with a, and I don't know, somebody might feel differently, but that they're looking at us, somehow differently because that's Travis County. What do y'all think?
You never want to get reversed, whether it's by, a court that's politically aligned with you or not, because just like when you issue an opinion, the hope is that you will have all of us agree, right? Like we're about, we have a lot of compromise in what we do, right? We're trying to reach a resolution that everyone can live with. But inevitably you're going to get reversed. I mean, I wouldn't know of any judge in the state that probably hasn't been reversed, right? At one point. Regardless. Yeah. And it's going to happen eventually. You just have to do your best. I would say one thing sometimes when we talk with staff, if staff are really, we're mulling over a case that seems difficult, there's a certain comfort in knowing we're not the last stop, right? We could get it wrong, and there's somebody else on the other side. There's 2 other courts on the other side that if we've truly misinterpreted the law or truly committed an error, it can be corrected. Very few things can we do that cannot be undone. And it's not the same right at the end of the line. Like that's a different type of responsibility.
And that's their responsibility. I mean, it is the highest court's responsibility to make policy, if you want to call it that. That's not what we got elected to do. And so in cases, my lawyers are always like, getting it right means not getting reversed. And I said, and then maybe it's because I was a trial judge and reversed by the third court so many times that I thought, no, that's not what right or wrong is. You're doing the best you can with what you have. And somebody else might look at it completely different. And so because you're reversed doesn't mean that you didn't get it right. It just means that those people didn't think you got it right. And that's okay, because that's their job. And so to me, it's just part of the system that it's, and that's the way it's supposed to work, right? If you're not happy with what a judge does, that should be your way to handle that. You appeal it, not you go on the radio or on TV and mention the name of the judges who ruled against you and, ask people to call their offices or show up at their houses, which is part of the politicization and just the craziness that we're living in.
I'd also add that the intermediate courts provide, even if ultimately there's an issue in which the Supreme Court and the Third Court of Appeals does not politically or philosophically align, the process of us providing to them the case law that supports a different view than they may have, that's a really important process. And so we are delivering to them something that they must consider in their analysis. And I think that process is just incredibly important.
If there's something that's unclear, or there's something that is only an issue that the Supreme Court or the Court of Criminal Appeals can resolve, that we can't resolve, right? Like, we have to follow their rulings, whether we agree with them or don't agree with them. That's just how it is. That's a good opportunity I've found to write something separately from my perspective. And I mean, I've literally said on more than one criminal case, please fix this issue, or here's an issue. We could use some guidance on X, Y, and Z. I mean, I'm phrasing it a little bit differently, but if there's something that's inconsistent, or something, or maybe their decisions are inconsistent, in the hopes that will spark they review so many things, right? Since they're courts mostly of permissive review, other than the CCA on certain issues, but they see something that sparks their interest, that, oh, no, this is an issue. We need to clear this up for the intermediate appellate courts. And sometimes that works, and sometimes that doesn't. But that's just another thing for us to do, to like give them something to talk about. Because if we issue an opinion that doesn't have any rationale, if that makes sense, then they're less likely to really take a hard look at one of those issues.
But it's also a good reminder that in a healthy organization, people disagree. You are not a monolith. You might all be female. You might all be Democrats. You still have your own opinions for good reasons, for a good rational basis. And you should be able to have healthy dissent all the time. There's nothing wrong with that. And so I think that this is a great reminder of that for the audience, that dissent doesn't mean screaming at each other and calling people names and going on TV and doing that and riling people up.
It's funny you say that, because since I've been on the court just for a few months, there have been a few dissents that have come through, and I had my first, and my only other experience is reading dissents like on the Supreme Court, U.S. Supreme Court, or something like that, and it can be very aggressive, and the dissent very. And one thing I love about working with these women is some of the feedback was like, you might want to make that a little bit nicer. You might want to make that. And I was like, I love that. I love that we can, disagree without being disagreeable. And that was something very valuable that I learned from them.
Well, and so that dovetails great into the question that I have for you. This is your first time as an elected official on a bench. What is reality like versus your expectations, besides getting nice feedback from your colleagues?
So it's funny. When I was a prosecutor, when I was in private practice, in different courtrooms, I remember I would be, the judge would be deciding the case, and I would think, man, I wish I could be making this decision today. And of course, I would want it to go my way. But I just remember thinking, I understand this case. I know this case. I wish I were the person sitting up there that got to make the decision. And then there were days where I thought, I am so glad I'm not the person up there having to make this decision. So the reality is, there are cases where I've done where I'm like, I have to make this decision. I have to follow the law here, and this is what the law says, and I have to make this decision. So I think, the reality is, it's tough. It's not easy to have to do something where you're like, I really wish this is not what the law said. And to have to make that decision. And it gave me so much more respect for all the judges that I appeared before.
Does it ever give you a crisis of conscience that you wish that you could have some different answer, but if you were going to follow the rule of law, you must give the answer that you have to give?
I'm not sure that it would rise to the level of crisis of conscience, but definitely, like, this doesn't feel good. Like, this is not how I wish this would play out.
And also it's an opportunity as a justice to, especially if a language in the statute may not have been thoroughly thought out on, the last few days before sine die, and maybe something got a little sideways as they were making the law. But it says, in English, it says X, and you can see all the bad consequences or unintended consequences of the way it was written. You can definitely send that message to the legislature in the way you write your opinion. You can also send that message. Let's say the whole CCA switches and you've got new judges on the CCA, and maybe we've got an old CCA opinion that we have to follow. We can signal to this new CCA that this is what the CCA said, and therefore we must follow it, although this or that, we can see this consequence, and then see if they will take up that nudge to take the law or the case law in a different direction.
Justice Kelly, why is it important to continue to encourage women to be lawyers and to run for office?
For a lot of women, they don't put themselves first, and they need that additional encouragement. And I've said this many, many times because I've been in situations where I was thinking about applying for something, and I was like, oh my gosh, but my male colleague is applying for it, and what if they don't have enough spaces for two of us, and I get it and he doesn't? And then I was like, well, who cares? And then you get it, but I think that's it's like the motherly instinct, right? And weighing all these different pieces. Should I do this? Well, how will this affect my family? And how will this affect this and this and this? Where I feel like our male counterparts are often like, I'll be amazing. Let's do it, right? And so for that reason, as women that are in the position that we're in, I think it's incumbent on us to tell other women, yes, you can be a lawyer. I mean, you talk about that all the time. You talk about that all the time. Yes, you can be in elected office. Why not? Why not run for that thing? Why not do that thing to give the extra little nudge? And I can think of times when I had that nudge and I needed that nudge because I wasn't coming up with some of those things on my own. And then that gave me the confidence to do other things, right? But it always helps to help, push your sister up the ladder, right? Like help remind that person how great they are. I've said this before, like sometimes you need to remind your friends that they're superstars because they don't always feel like they're superstars. There are times when they're going to feel terrible. So, but with our profession, we have so many women who the problem isn't so much going to law school in terms of female law students. I mean, at UT, the past few years, women have outnumbered men, okay? It's this after 5 or so years, what happens? And it becomes the additional job of family, children. You have all these other responsibilities. So how do all those square with being a lawyer? And that's something that I think the profession has struggled with and continues to struggle with because it's a lot. Because you're almost always going to be called on to be the primary caregiver, regardless of what you both do. So what are the things and tools that can help women navigate being in a law firm, being in a DA's office, being a judge, right? And how can we creatively think about those? Because I don't think anyone would ever say, oh, well, those women do less work, so that's why they have to leave the profession. No, they're doing 4 times the work. But what's the best way to channel that and just to remind them, like, this is okay, I mean, look here, right? Like, we all have families. I was a little later at the start than the rest of my colleagues, but it can be done, and it has been done, and it has been done for generations. We just need to recognize it more when it happens and encourage the normalcy of it, if that makes sense.
Well, and as a plug, most lawyers I know want to grow up to be judges, which is wonderful. However, based on what we were just talking about, we need smart lawyers to go into the legislature and to go to the executive branch. We need smart people in all 3 branches so that they all lift up. So audience, run for state rep, run for state senator. Nothing would be more thrilling than arguing from the back mic, in my opinion. And as judges, you must be statesmanly, and that's great. But you don't get to change the law. And so sometimes I'll hear what I would call activist attorneys talk about how I want to be judge because I'll change it and I'll make sure that doesn't happen. And that's not where you do it. So as we end the legislative session, please run for office, smart people. I understand the legislature only gets paid like $600 a month, and so that's a deterrent. But if you can make it, run for that as well, because I think we need all branches to be healthy and thriving. Because it can't only be the judicial branch trying to keep things steady. It has to be all of it, and has to work together with all the smart people.
And Amanda, do you feel like it seems that there are fewer and fewer attorneys running for state legislature. And I'm sure much of it is money. The same thing for the judiciary. I think we are 49th in the United States on pay for judges. And, our legislators don't make much except they do get name recognition, and then somehow they start making a lot of money outside the session.
Justice Theophanis, since not all of our listeners do appellate work, what advice would you give to lawyers who are coming before the third court for the first time?
The first thing I would tell lawyers who are coming before the third court for the first time is to go to our website, which sounds like such a generic piece of advice, but our website actually has an incredible amount of information on it. As a judge, I use it many, many times a day. When I was a full-time appellate lawyer with the Travis County DA's office, I was on it constantly. So for the complete newbie, there's sort of a practice guide, and it's extremely practical. So it has things like, we use Blue Book, which, that's maybe not so surprising, but there are other facts like how to file things in our court and all kinds of really practical practice tips that you can get from the practice guide. But in addition to that, it has a lot of information about current cases. So you can look and see what cases are on submission now. Another thing, like if I were a lawyer who hadn't done an appeal before, I might think of like who's a superstar appellate lawyer. You can look up cases by their name. So you could put their name in it and find out, here's a brief they recently filed. This is kind of the level at which they're playing, which is really helpful. If you have access to Lexis and Westlaw, you could say, okay, here's let's say you're doing an employment law case. You could find a case that we had decided that was an employment law case. You could get on the website. You could access all the briefing in that case. You could sort of see what the pace of the case is. There's just like a lot of information if you know how to use that website. And I would say the same is true for Supreme Court, Court of Criminal Appeals. I use it to track cases in those courts, to this day. It also links to recordings. So if you wanted to listen in on a prior appellate argument, you could listen to an oral argument we had in our court. Now we record a lot of things on YouTube, so that's another place that you could look to see a recorded argument. Try to think of other things you might use the website for, but it also has contact information, how to get a hold of our court. There's a lot. It has bios of the justices. So if you know, okay, this is the panel for my case, what do I know a little bit about these people and their background, to better tailor your argument to, what our background experience is. Another thing I might do would be rely on our clerk's office. We have a wonderful clerk, Jeff Kyle. We have incredibly talented deputy clerks, and they're very friendly as well. So if you call, you're not going to get the stiff arm. They are very good with practitioners, helping them understand the process. They want people to succeed in our court. So I'd say that's another resource I would point a new appellate lawyer to. I would also encourage them to talk to someone in the bar that does appellate work. Coming up in the Travis County DA's office, I always felt very fortunate because there were always lawyers that were a few steps ahead of me, both as a trial attorney and an appellate attorney. So I could run my entire argument by them, or have them read my brief, or read something they'd done on a similar topic, or, problem solve an area in an appellate brief I was working on. So a new lawyer, if you can find someone in the bar, and in my experience, the Travis County bar, the Austin bar, are very friendly and willing to help each other out. So you can find someone who's done this work. That's going to save you a lot of guesswork. You can just ask them, like, what's your experience in asking for a continuance? Do you think they're going to give it to me? And I think people will be very forthcoming. So those are some of the things that I would suggest. And then come to an oral argument. Come to our court. On the website, there's this case submission thing. It shows submissions on oral argument. It shows the schedule, what the panel is, what the case is. Find a case that seems interesting to you and just come into our courtroom. I think the live experience, in my opinion, is more compelling than a recording, just because you get the whole feeling of what the courtroom is. And so anyway, that's a great way to get started.
Have you seen any major pitfalls that attorneys have fallen into when they have been before you?
I think that would be one of the reasons why I would say watch an argument, like come prepared to give the argument that we want to hear. I'll give a positive example to start with. Like recently we had an attorney that came in, and this was a case that we had that was on remand from the Texas Supreme Court. So it had already been heard by our court one time. And so one of the big tasks of it was like figuring out what is left to decide in this case. And the lawyer stepped up to the lectern and was like, here are the 4 issues you still have to decide. And that's like exactly what we wanted to hear. And so An example of something that we don't want to hear would be like a recitation factual of what happened in the case. I think lawyers should assume that we've read the briefing, that we know the background of the case. And so you're basically, not using your time well if you spend a lengthy part of your argument sort of summarizing what happened factually in the case. You're missing an opportunity to like actually argue to us.
And I think for trial lawyers, it's a little different because being a trial lawyer is so different than being an appellate lawyer. Being a trial lawyer, it's all about performance. It's all about, getting, at least laying it out right there in front of everybody, getting your side of the story out. I don't think anybody on the Court of Appeals appreciates snarkiness. None of us appreciate big dramatic. It's like, okay, you got 20 minutes, so be very careful in what it is that you choose to talk to us about.
Because we've had a few demonstratives. I mean, more than one case with like big, foam board or like physical things that people bring, and it's just I've never seen it used effectively. Right.
The only one that I think is good is chronology. Sometime in a complex case, and that being tendered to the court before you come to OA, that's a wonderful thing to
Like
get.
a 1 page, right? 1 page chronological, or if you have a lot of acronyms, 1 page of who are the parts. Something like that is good, but don't give us more briefs. We've already read your
We've had things like either in the body of the brief or as an exhibit for oral argument, like in statutory construction, like where there's this language and it's referencing different things, right? Like in different boxes, sometimes that can be helpful. But like a physical thing that you want to get up and show, like you would show a jury, we can't see it often if you're holding it, that it's further back. Because we had a case a few years ago with like a big printed out board and they're pointing to different things on the board. Well, if you have something you want to show us, maybe it's a map or something that's really important in the case, an exhibit, put it in that, file it before OA, and then each judge gets a copy of it, and then we have it up there at the bench. That's much more effective than the big thing in the courtroom.
And also know what you're asking for. What do you want us to do at the end of the day? That seems to be lost often, which is surprising.
I think Justice Kelly is correct. We're not the jury. We're not going to be swayed by theatrics or, big dramatics or arguments.
And we have had some things recently where we ask questions about the record, and the lawyer's like, "Well, I don't know. And it's like if we ask a question about a thing, right? If you don't know the answer, you can say, well, Your Honor, I don't know. May I have permission to file, a post OA, what is it, post-submission brief or post-submission letter to clarify. I can look that up. Like, even if you don't have the answer, you can offer to solve the problem. And maybe it's a point that's not that important, but sometimes we'll just have people say, no, I don't know.
Or maybe say it's not in the record. We don't know that. If it's not in the record, it's not in the record. But yes, I don't know. And 2 things on that. If we're a pretty hot bench in the sense that we ask a lot of questions and we're very mindful that we don't have a lot of time. So if you're, spending time kind of telling us the facts of the case, we're going to interrupt you and we're going to say, what we really want to know is this. So be ready for that. And to be flexible because, and I thought of this when I was a trial judge, when you ask a question and they're like, I'll get to that. Because you've got your whole argument prepared. This is all argument. That's why we call it oral argument. And it's like, that's my point 3B, and I'm at 1. I'll get there. All I'm going to be thinking about till you get there is, are you going to answer my question? So anything you're saying, it's sort of like peanuts, right? It's like, no, if I asked you a question, it's because it's pretty important. Address the question, even if it's to say, off the top of my head, I can't, but, I'll find out for you. I'll, can I submit? Do I have to leave court to submit post brief, whatever?
And when you're asking the question, you're not trying to ask a gotcha. No, you actually want to know the answer to the question. So this is not class. This is not the Socratic method.
No, and it's not the U.S. Supreme Court where I'm going to set you up because, I want you to answer a question my way so I can go back and argue it, the way that I want it. Or I want you to answer a question that you can't answer. No, I've never seen that in our bench where somebody has knowing the answer or not knowing if we're asking you a question, we really want to know.
And one thing I think the audience needs to know that each person here is pretty much responsible on an annual basis for writing 120 opinions. And each person here reads everybody else's opinions. We don't have time to do gotcha. It's just, we got work to do. So, help us out. That's what we're after, is help us out so that we can give you an opinion soon. And hopefully we're going to get it right. And that's our goal.
And I've seen sometimes in our court and also in Supreme Court arguments, a judge gives a hypothetical and the advocate refuses to accept the confines of the hypothetical and thus refuses to answer the question. And again, you don't have to agree. I mean, sometimes advocates sort of see where it's going, but sometimes you have to make concessions, and you could say, well, under that scenario, this, but that's not what we have here, instead of, well, that's not what happened here. And you just get dug further down, because then the other judges will say, well, why haven't you answered, Judge Burns, the Chief Justice Burns hypothetical, or why, but you got to accept the premise, even if it's not perfect for you at the end of the day.
Justice Crump, in your time as a judge, you've done a lot of campaigns. What advice would you have for lawyers who want to run for judicial office?
I think the first thing that you have to do is know thyself. Who are you, and why do you want to run for office? Is your motivation because you truly have a desire to do the service that you mentioned earlier? Are you wanting to make a difference in this particular area? What is it? What motivates you? And are those true motivations? And have you considered the impact on the rest of your life? Campaigns take a long, long time, particularly if it is a campaign where you will have both a primary and a general, and I've run several of those. That means that you have to really prepare for an 18-month or more in preparing your life and preparing your campaign and preparing an infrastructure of supporters who will be with you throughout that entire period of time. Are you financially ready? Do you have a partner who, or yourself? That's fine too. But is your life partner willing to support you throughout that long period of time, financially, emotionally, on the bad days, on the good days? And do you have? It's kind of like starting a law firm. If anybody's done that, what they tell you when you're going to start your own, just hang out your own shingle. Yeah, you have to have that 6-month leeway. You have to have that money in the bank to prepare yourself if you are in private practice where you can't do it, or you're at the DA's office or somewhere else where you can't do the campaigning while you do your full-time job. And so, are you prepared financially to do the campaign while you're working or outside of work? Have you looked into your privacy, the privacy aspects of your life? Because if you win, you're going to become a very public figure, and that means that the public is going to want to know about you, including where you live and who your children are, and many have not proper interest in that. And so, if you're going to be thinking about running for judge, you want to be thinking about do a Google search of yourself. What comes up? Does your home address come up? And if so, you need to be thinking long before you file your treasurer's report or your designation of a treasurer. Long before you do that, you want to make sure that you've scrubbed things that would release your private information to the public. And that can be done, but it's a difficult and it's a process that takes a lot of time, and it's something that you have to maintain. But particularly if you're going to run for a district judge position where, you're going to be making decisions that remove children from their parents, or you are removing money from individuals or companies, that makes people really, really angry, and you can often become the target of their anger. And so you just want to take precautions. You have to be really thoughtful. I mean, are you okay with that? And you have to balance, like, is the service, is this desire to be in public service, is it enough such that you are willing to give up the private side of your life? Are you willing to subject your children to that danger? Are you willing to subject your partner to you being in danger? And all of those things, having been a judge now for over a decade, I've had police officers spend weeks outside of my home because of an active threat. And many of us have experienced that. It is unfortunately very commonplace. And so you can't really, you have to accept that that is a known risk, like many other things that you do. If you go scuba diving, there's a risk that something could happen. If you run for judge and you become a judge, there are known risks. And you just have to be comfortable with that and know that it's worth it. And all of us have sort of said, we've decided to do this despite the risks. There's, I think, less of that on the appellate bench, but, particularly for those, CPS cases and things like that, criminal court judges, it's a pretty high risk. And so, for sure, you want to think about those kinds of things. But also, like, less, tragic and less serious is just, who are your supporters in life? Who are your cheerleaders? And kind of coupling together those people who will be there for you and who will give you money and who will support you thick and thin during a campaign. What's the worst thing that people are going to say about you? And so you should be prepared for those things to be said, because campaigns are rough and tumble. Like, you have to have thick skin. You have to be willing to be in a process where people are going to say ill things about you, because they want that job too, and their supporters want it for them. And so you have to be okay and comfortable with negative things being said about you, and just get right back up, brush it off, and keep going, because hopefully you're in it for the right reasons, and that nose forward, stay on the path. You just keep on going, keep your chin up. If you could do those sorts of things, then this is probably the right job for you. But if these types of things sound really terrible, then you don't want to do it. It won't be worth it to you, because, as previously mentioned, we make less money than judges in Guam. I mean, we are the bottom of the barrel in terms of pay, judicial pay. And it's unfortunate, because it's a truly, really important job. It's a noble profession. And it's one that all of us really, really enjoy doing and are glad to do because of the service. It's really, really important, and we care about it, and we care about the opinions that come out. And as everybody else mentioned, we really, we work very closely with our staff attorneys in ensuring that the work product is really, really important to us, that we work hard enough to ensure that we get it right. And all of us, every single person on this court is working really hard every single day to ensure that our decisions are correct, and that they have been thoroughly checked, and that that we are doing something to promote the rule of law.
So it sounds like there's a hierarchy of needs. If you think you want to run for office, first you need the basic level of, I can do it, even though I'm a woman, even though I have family obligations, I can do it. And then, do I want to do all of those things? Because you might do all of those things and be the best candidate, have all the money, and still lose.
So 3 of us have lost, and you have to be willing to lose.
You have to be willing to say, I have nothing to lose but this race.
You also need to know if you're comfortable picking up the phone and asking for money. Because as long as we have an elected system, you must raise money in order to get your message out to the voters. It's just a necessary evil. And some people are really comfortable doing that. And it's not for everyone, because that's hard. You have your cobbled together list of all the people that will support you thick and thin. Are they willing to put money into this campaign to support you to go? Because these campaigns, I think recently upwards of hundreds of thousands of dollars you have to raise in order to get your message out, particularly when you have a race of 24 counties and thousands of voters.
And one thing that your viewers may question after you've heard from Justice Crump, why in the world would you want to do this, and why in the world do we elect judges? And that is a philosophical and policy decision that states do very differently. And we in Texas love our elections, and we love them to be partisan. That's kind of what we do here in the state of Texas. And, after thinking about my pathway to the bench and many of my colleagues here pathway to the bench, but for it being an elected office, I would not be here. Because you juxtapose some of the alternatives, which are appointment. Well, as we know, there hasn't been a statewide elected Democrat in the state since Governor Richards. And so, it is political when you're appointed. So if your party is in power, your party will likely appoint judges that happen to be like that party. Therefore, I would have never been on the bench, but for elections, as hard as it is, you meet the people you are serving. You go door to door, you shake their hands. Some of them close the door in your face, but many of them do not. Offer you a glass of water. Let's talk. What's your story? And you get to know what the community you serve believe in. And to me, being on the bench and having Austin, Travis County be really mine, because I had been in all the neighborhoods, and the 24 counties be really mine because I have gone to every one of those counties. It matters to me, and it really lets you know who put you in office and who you're there to serve.
They're our bosses. Every door that you knock on, that's me. You report to the people who elect us. And kind of going back to your question earlier about the reality versus the expectation, I thought, I love researching. I love researching my pajamas. I think I would really love this job. And so to Justice Crump's point, and you're asking, why would you do this? I found in my 4.5, 5 months on the bench, I love it even more than I thought I would. I think it's absolutely worth all of the time, the thousands of miles, the knocking on doors. So if anyone was dissuaded, don't be.
So our final question, will this be the last time that the Third Court of Appeals is all female?
I really think that it will happen again. Will it happen this next election? I don't know. I'm the only one on the ballot amongst us, so I don't know. But I think it will. I think we will have an all-woman court again. Do I think it will be mixed gender again? Oh, yes, I do. Certainly, that is. Do I think it will be all men again? That's a harder question. I think with the number of women that are in the field of law these days, that may not be a place that men gravitate toward.
This is important because it's now, and it's sort of the same reason that we started the podcast, right? There's nothing really interesting about having a Hispanic bar president. except that it took until a couple of years ago to have a Hispanic female bar president, and it's Austin. And we pride ourselves on being diverse and welcoming all the people. So that's why we started this, so that we could start telling these stories about, maybe you don't think it's the coolest thing that's ever happened, one audience member, but it's pretty darn cool. But thank y'all for being here, for being so open and honest. And I think that the viewers are going to love this one.